You are on HOA catastrophe. The portal history was the smoking gun. I am not the one you bully. That is what I wanted to say when Catherine stormed up my driveway with printed screenshots clutched in her fist, screaming that my portal access was being restricted for asking questions. She waved the papers like they were court orders, her face red, her pink windbreaker catching the midday sun. I work as an IT compliance auditor, which means I spend my days reading logs, tracking timestamps, and catching people who think they can hide bad data. Catherine Wright did not know that. She thought I was just another homeowner she could steamroll with procedural threats and fake authority. She was the board secretary for Canyon Springs Commons Association here in Buffalo, New York, and she controlled every piece of paperwork that moved through this neighborhood. That was her power. That was also her mistake. The portal thing was new. 2 weeks ago, I had logged in to check the association financials because I was refinancing my house, and the lender wanted proof there were no special assessments pending. That is when I noticed the ledger showed a quarterly grounds maintenance fee that was not in my closing documents. I submitted a simple question through the portal, asking for the covenant section that authorized it. 3 days later, Catherine replied with a 2-line message saying the fee was approved by the board in executive session and was not subject to member review. That did not make sense. HOA budgets are membership business. I replied asking for the meeting minutes. She ignored me. Then my portal access stopped working. I could not log in. The password reset link sent me to an error page. I called the management company, and they said my account was flagged for administrative review pending compliance with document request protocols. I did not have document request protocols. I had asked one question. That same afternoon, I came home to find a bright orange warning tag zip-tied to my windshield. No readable text, just a generic tow company sticker with a phone number and a checkbox marked. The timing was too perfect. I pulled the tag off and took a photo, then went inside and started digging through my old emails. Canyon Springs Commons is the kind of development where the committee micromanages everything and calls it standards. You cannot park your work truck in your driveway overnight. You cannot put trash bins out more than 12 hours before pickup. You cannot plant anything without submitting a landscaping variance form. Every rule has a subclause, and every subclause has a penalty schedule. Catherine ran the paperwork side of that machine. She was the one who drafted the violation notices, printed the hearing agendas, and kept the official minute book. If you wanted to see a record, you had to ask Catherine. If you wanted to dispute a fine, you had to submit your appeal to Catherine. If you wanted to know what the board actually voted on, Catherine gave you a summary she wrote herself. I had moved here 18 months ago because the mortgage rate was good and the neighborhood looked quiet. I thought I could keep my head down, pay my dues, and avoid the HOA circus. That worked fine, until I needed to refinance. Now I had a lender breathing down my neck for proof of no liens, a tow warning on my car, and a board secretary who was ghosting my records requests. The tow warning was the trigger. I recognized the vendor name from a neighborhood group chat thread 6 months ago. Another resident, a guy named Eric, had posted about getting towed from his own driveway for an expired registration sticker. He said the HOA had called in the tow without any prior notice, and he had to pay $300 to get his car back. When he asked Catherine for the violation documentation, she told him towing was handled by the management company and was not subject to board review. Eric posted screenshots of his correspondence. Catherine had replied to every question with a variation of the same line. The policy was approved, the procedure was followed, and the matter was closed. No citations, no covenant sections, no meeting minutes. Just Catherine saying it was done, and that was final. I remembered that thread because Eric had also mentioned that his original violation notice was dated 2 days after the tow. He said he only found out his car was gone when he went outside to leave for work. The notice showed up in his mailbox that afternoon, backdated to look like he had been warned. That sounded a lot like what was happening to me. I had a tow warning, but no prior violation notice. I checked my mailbox, my porch, and my email. Nothing. I logged into the neighborhood portal, except I could not because my access was blocked. So, I called the management company again. The property manager, a woman named Lisa, answered with a forced smile in her voice and said Catherine had flagged my account for records tampering. I asked what that meant. She said someone had reported that I was screenshotting confidential board documents and sharing them with non-residents. I told her I had not shared anything with anyone, and I had not even been able to log in for 3 days. She said she would escalate it and get back to me. She did not get back to me. The next morning, Catherine showed up at my door with a tabbed binder. She did not knock. She rang the bell, and when I opened the door, she was already talking, telling me that my vehicle was in violation of parking covenants, and that I had 72 hours to correct or face a $50 daily fine plus towing and storage fees. I asked her which covenant. She flipped open the binder, ran her finger down a page, and said Section 4.7, subsection C, unauthorized overnight parking of commercial vehicles. I drive a Honda sedan. It is not a commercial vehicle. I pointed that out. She said the tow company had flagged my car as a possible work vehicle due to equipment visible in the back seat. I asked what equipment. She said that was between me and the tow vendor, and I needed to contact them directly for reinspection. Then she snapped the binder shut, turned around, and walked back to her car. Reinspection. That was a new word. I went back inside and pulled up the covenants on my laptop. Section 4.7 covered parking restrictions. Subsection C said commercial vehicles over 10,000 pounds were prohibited. My car did not qualify. There was no mention of reinspection, no mention of tow vendor discretion, and no mention of equipment in the back seat. I had a laptop bag and a gym duffel back there. That was it. I called the tow company. The dispatcher said they had no record of a reinspection request, and that the warning tag was issued based on an HOA complaint. I asked for a copy of the complaint. He said I would have to request that from the HOA. I asked if there was a specific violation noted. He said the tag was generic, and that the HOA would provide details. Then he said if I wanted to avoid towing, I should move the vehicle off the property until the matter was resolved. I asked him where he thought I should park my car. He said he did not know, but that was not his problem. That was when I realized this was not about my car. This was about making me fold. Catherine was using the tow vendor to create fake urgency and invented reinspection fees, and she was betting I would either pay to make it go away or move out and stop asking questions. I did neither. I went to City Hall. Buffalo has a public records clerk who handles HOA covenant filings. I did not know that until I Googled it, but once I found the office, I walked in and asked for the official Canyon Springs Commons declaration. The clerk, a patient older man named Tom, pulled up the digital file and asked if I wanted a printed copy. I said yes. He printed it, stamped it, and handed it to me. I sat in my car in the parking lot and read the whole thing. Section 4.7 was there. Subsection C was there. There was no mention of reinspection, no mention of tow vendor authority, and no mention of equipment-based violations. The only commercial vehicle restriction was for trucks over 10,000 pounds, which was standard. I took photos of every page, then drove home and started going through my emails again. I was looking for anything that mentioned the grounds maintenance fee Catherine had cited. I did not find anything in my inbox, but I did find something in my spam folder. It was an email from 8 months ago, sent by someone named Glenn Morris. The subject line was question about quarterly assessment. Glenn had replied to a neighborhood listserv thread, asking if anyone else had received a bill for a new grounds maintenance fee that was not in their budget. 3 people had replied saying they had also received it. One of them said she had called Catherine to ask about it, and Catherine told her it was a budgeted line item that had always been there but was previously rolled into dues. That did not match what Catherine had told me. She said the fee was approved in executive session. If it had always been there, it would not need approval. I called Glenn. He did not answer, so I left a message. Then I opened my portal recovery email and looked at the error message. It said my account was locked due to administrative flags, and I needed to contact the board secretary for resolution. No instructions, no timeline, just a loop back to Catherine. I decided to escalate. I wrote an email to the entire board using the addresses listed on the HOA website. I kept it short. I said my portal access had been blocked without explanation, I had received a tow warning for a violation that did not match the covenants, and I was requesting an immediate written response with citation to the relevant rules. I CC'd the management company. Catherine replied within an hour. Her email was one sentence. Complaint log entries are reviewed on a rolling basis, and residents will be notified of findings in accordance with administrative timelines. That was not an answer. That was a stall. I replied asking what the administrative timeline was. She did not respond. Glenn called me back that evening. He sounded tired. He said he had gone through the same thing I was going through. He had asked about the grounds fee, and Catherine had sent him a violation notice for unapproved exterior paint color. His house was beige. It had always been beige. It was the same color as 6 other houses on the block. He fought it for 2 months, and eventually the board dropped it, but only after he paid a $150 administrative review fee. He said the review fee was not in the covenants either. He said Catherine had told him it was a standard cost recovery provision, and if he refused to pay, the matter would go to collections, and a lien would be filed. If you are enjoying this, hit like and subscribe so you do not miss the next story. He paid. He said it was not worth the fight. Then he stopped asking questions about the fee. I asked Glenn if he still had the violation notice. He said he did. I asked if he could send me a photo. He said he would, but he did not want his name attached to anything public. He said Catherine had a long memory, and he did not want to be next on her list again. Glenn sent me the photo an hour later. The violation notice was printed on HOA letterhead with Catherine's signature at the bottom. It referenced Section 6.3, exterior color compliance, and said his paint color deviated from approved palette standards. The notice was dated March 15th. Glenn said he received it March 20th, 5 days after the date printed. I pulled up Section 6.3 in the covenants. It said exterior color changes required advance approval, but it did not list an approved palette. It did not say existing colors could be challenged. It did not mention administrative review fees. I had 2 things now. Catherine was backdating notices, and she was inventing fees that were not in the covenants. That was a pattern. I just needed more proof. I went back to the neighborhood group chat and searched for Catherine's name. There were dozens of threads. Most of them were people asking procedural questions, and most of Catherine's replies were variations of the same deflection. The policy was approved. The procedure was followed. The matter was closed. But there were a few threads where people had pushed back, and those threads all ended the same way. The person got hit with a violation, paid a fee, and stopped posting. One thread caught my attention. A woman named Angela had posted about getting a violation notice for holiday decorations in January. She said she had taken the decorations down the day after New Year's, but the notice was dated December 28th and said her lights were still up as of January 3rd. She posted a photo of her house with no lights. She said the notice was impossible because she had been out of town until January 2nd. Catherine replied saying photographic evidence was not accepted for compliance disputes and that Angela needed to submit a formal appeal with a $50 filing fee. Angela posted one more time asking why she had to pay to dispute a notice that was factually wrong. Catherine did not reply. 2 weeks later, Angela posted that she had paid the fine and the appeal fee because she did not want it to go to collections. That was 3 people. 3 violations that did not match the covenants. 3 backdated notices. 3 invented fees. I screenshotted every thread and saved them in a folder. The next morning, I got another email from Catherine. This one had an attachment. It was a formal notice of violation hearing scheduled for the following Tuesday at 7 p.m. The attachment listed 3 violations: unauthorized overnight parking of a commercial vehicle, failure to respond to compliance correspondence, and misuse of association digital resources. The third one was new. I had not misused anything. I had asked a question, and she had locked me out. Now she was claiming I had done something wrong. I opened the attachment and looked at the details. The hearing was listed as mandatory. Failure to appear would result in automatic findings and immediate penalty assessment, including fines and lien filings. The notice said I could submit a written defense in advance, but it had to be received by Catherine no later than 72 hours before the hearing. That gave me 3 days. I called an attorney. I had never needed an HOA lawyer before, but I knew I was past the point of handling this myself. The attorney, a guy named Paul, listened to my summary and said it sounded like selective enforcement and procedural abuse. He said if Catherine was backdating notices and inventing fees, that was fraud, and if she was doing it systematically, it was a pattern that could support a lawsuit. He said the first step was to get my hands on the association's official records, starting with meeting minutes and complaint logs. I told him I had tried. I told him Catherine controlled the records and was stonewalling me. He said I had a legal right to inspect HOA records under New York law, and if she refused, I could file a formal demand and escalate to a court order if necessary. He said he could draft the demand letter, but it would take time, and my hearing was in 3 days. I said I would handle the hearing myself and follow up on the demand letter after. Paul said that was a bad idea. He said Catherine would railroaded me in the hearing, and anything I said could be used against me later. I told him I had evidence. He asked what kind. I said I had backdated notices, screenshots of selective enforcement, and proof that the fees she was charging were not in the covenants. He said that was good, but I needed to be careful. He said if I accused Catherine of fraud in a hearing without corroboration, she could claim defamation and flip the whole thing on me. He said I needed independent documentation, ideally from a neutral third party. I asked him who that would be. He said the management company, the board treasurer, or a forensic audit of the HOA's financial records. I told him the management company was in Catherine's pocket, the board treasurer never replied to emails, and I did not have time for an audit. Paul sighed and said I should at least get a witness, someone who could testify that the violations and fees were inconsistent with past practice. I told him I had Glenn and Angela. He said that was good, but I needed someone with authority, someone the board could not ignore. I thought about that. Then I remembered Tom, the city clerk. He had the official covenant filing. If I could get him to testify that the covenants did not authorize the fees, that would be neutral third-party proof. I called the clerk's office and asked if Tom could provide a certification letter confirming that the covenants I had received matched the official filing. The receptionist said that was a standard service and it would cost $10. I said I would pick it up that afternoon. Tom had the letter ready when I arrived. It was 1 page, printed on city letterhead, with a stamp and his signature at the bottom. It said the attached covenants were a true and complete copy of the Canyon Springs Commons Declaration of Record as of the current date. I paid the $10, thanked him, and left. I now had proof that the covenants Catherine was citing did not exist in the official filing. That meant every fee she had charged based on those fake rules was fraudulent. I just needed to prove she knew they were fake. I went home and started going through the HOA's website. Most of it was generic boilerplate, meeting calendars and contact forms, but there was a document section with downloadable PDFs of the rules and regulations. I clicked on the covenants link and downloaded the file. It was different from the one Tom had given me. The website version had extra sections. Section 4.7 included a subsection D that was not in the official filing. Subsection D said commercial vehicle determinations were subject to vendor inspection and re-inspection protocols as established by the board. Section 6.3 had a palette chart attachment that listed approved colors. There was a whole new Article 9 about administrative fees, including review fees, appeal fees, and lien preparation fees. None of it was in the official covenant filing. Catherine had 2 versions, one for the county, one for the residents. The residents only saw the stricter one. I took screenshots of both files, side by side, highlighting the sections that did not match. Then I opened my email and started drafting my written defense. I kept it short. I attached the city clerk certification letter and the side-by-side comparison. I said the violations cited in the hearing notice referenced rules that did not exist in the recorded covenants, and I requested the board provide legal authority for enforcing unrecorded provisions. I CC'd the entire board, the management company, and Paul. Then I hit send. Catherine replied 10 minutes later. Her email was 2 sentences. Your submission has been received and logged. Per administrative protocols, late filings are not guaranteed review prior to hearings. I checked the timestamp. I had submitted it 74 hours before the hearing. I was inside the deadline. Catherine was lying. I replied, pointing that out. She did not respond. The hearing was on Tuesday. I showed up 15 minutes early. The meeting room was in the clubhouse, a generic beige box with folding tables and metal chairs. Catherine was already there, sitting at the head table with her tabbed binder open in front of her. The board president, a gray-haired man named Richard, sat next to her, looking bored. 2 other board members sat on the far end, scrolling their phones. There were no other residents, no Glenn, no Angela, no witnesses. Just me, the board, and Catherine. Richard opened the meeting by reading a script about hearing procedures. He said I would have 5 minutes to present my defense. The board would ask questions, and then they would deliberate and issue findings. He said the hearing was being recorded for record purposes, and I could request a copy of the recording by submitting a written request to Catherine. I asked if I could record it myself. Richard said no, personal recordings were not permitted. I asked why. He said it was board policy. I asked to see the policy. He looked at Catherine. She flipped through her binder and said it was covered under administrative discretion and was not subject to member review. I let it go. I did not need a recording. I had my evidence. Richard asked me to present my defense. I stood up and laid out the city clerk's certification letter and the side-by-side covenant comparison. I said the violations I was cited for referenced rules that did not exist in the recorded covenants, and I was requesting the board explain the legal authority for enforcing unrecorded provisions. Catherine did not look at the documents. She looked at Richard and said the covenants on the website were board-approved interpretive guidance and were enforceable under the association's general management authority. She said the official filing with the county was a base document, but the board had discretion to adopt operating rules that clarified ambiguous provisions. I asked which provisions were ambiguous. She said Section 4.7 did not define commercial vehicle, so the board adopted a definition that included any vehicle used for work-related purposes. I pointed out that my car was not used for work-related purposes. She said the tow vendor had flagged it based on visible equipment, and that determination was final. I asked to see the vendor's report. She said vendor communications were confidential. I asked who made them confidential. She said the board did, in executive session. I asked for the meeting minutes. She said executive session minutes were not subject to disclosure. Richard cut in and said we were getting off track. He said the hearing was about whether I had violated the rules as posted, not whether the rules themselves were valid. He said if I wanted to challenge the rules, I could file a separate petition, but that was not the purpose of this hearing. I said the rules Catherine was citing did not exist in the covenants, and enforcing fake rules was fraud. Catherine stood up, slammed her portable rolling stamp pad on the table, and said I was out of order. She said accusing the board of fraud was defamatory and could result in additional penalties. Richard told her to sit down. He told me to watch my language. Then he said the board would take my submission under advisement and issue findings within 10 business days. I said I wanted a ruling tonight. He said that was not how it worked. I said Catherine had threatened me with immediate lien filings if I did not appear, so I wanted immediate findings if I did appear. He said the board needed time to review the materials. Catherine said the materials had already been reviewed, and the findings were clear. She said I had failed to comply with parking restrictions, failed to respond to compliance correspondence, and misused association resources by submitting frivolous records requests. She said the recommended penalties were a $250 fine for the parking violation, a $100 fine for each of the other 2 violations, and a $50 daily penalty for continued non-compliance until my vehicle was moved or re-inspected. I asked her to define re-inspected. She said I needed to contact the tow vendor and schedule a re-inspection at my own cost. I asked how much that cost. She said it varied. I asked for a range. She said that was between me and the vendor. I asked the board if they were going to let her invent fees. Richard said the board had authorized the tow vendor to enforce parking rules, and vendor fees were not within the board's purview. I asked who authorized it. He said the board did. I asked when. He looked at Catherine. She said it was approved in executive session. I asked for the meeting minutes. She said executive session minutes were not subject to disclosure. I sat down and pulled out my phone. I opened the folder with the screenshots from the neighborhood group chat. I found Angela's thread about the holiday lights and held up the screen. I said Catherine had backdated violation notices before, and I had proof. Catherine stood up again and said my camera did not matter. Her minutes were the truth. I asked Richard if he wanted to see the proof. He said no. He said the hearing was about my violations, not about Angela's or Glenn's. He said if other residents had complaints, they could file their own petitions. I said this was a pattern. I said Catherine was using backdated notices and fake fees to silence anyone who questioned her, and the board was enabling it. Richard said I was out of order again. He said the hearing was over and the board would issue findings in writing. I said I was not leaving until I got answers. Catherine said if I refused to leave, she would call security. I asked what security. She pulled out her phone and said she would call the police and report trespassing. I told her to go ahead. She did not dial. She just held the phone up like a threat and repeated her line. If you make me repeat myself, it gets more expensive. Richard stood up and said the hearing was adjourned. The other board members grabbed their things and left. Catherine stayed seated, staring at me. I stared back. Then I gathered my documents and walked out. I did not play my hand yet, and she thought that meant I had none. I went straight to Paul's office the next morning. I brought everything: the city clerk certification letter, the side-by-side covenant comparison, the screenshots from the neighborhood group chat, Glenn's backdated notice, and Angela's thread. I laid it all out on his desk and said I needed him to file a formal records demand and a complaint with the state attorney general's office. Paul looked through the materials and said I had enough for a fraud case, but the attorney general would take months to investigate, and I needed a faster fix because my refinance deadline was 2 weeks out. He said the best move was to demand the association's financial records, including the general ledger, bank statements, and all fee receipts for the past 2 years. He said if Catherine had been collecting fake fees, the money had to be going somewhere, and if it was not in the association's accounts, that was embezzlement. I asked him to draft the demand letter. He said he would, but it would cost me a retainer. I paid it. He had the letter ready that afternoon. It was 3 pages, citing New York HOA law and demanding full access to financial records within 10 business days. It named Catherine and the management company as custodians and said refusal to comply would result in a court filing. Paul sent it certified mail. I got a tracking notification that it was delivered 2 days later. Catherine did not respond for a week. When she finally did, it was through the management company's attorney. The reply letter said the association's financial records were confidential under attorney-client privilege, and that my request was overly broad and burdensome. It said if I wanted specific documents, I needed to submit an itemized list with justification for each request. Paul called me and said that was nonsense. He said financial records were not privileged, and the law did not require me to justify a records request. He said we could file a motion to compel, but it would take at least a month to get a hearing date, and I did not have a month. I asked him what other options I had. He said I could show up at the next board meeting and demand access in person. He said if Catherine refused in front of witnesses, that would strengthen our case. He said I should bring a camera and record the whole thing. The next board meeting was Thursday. I cleared my schedule and showed up 30 minutes early. Catherine was already there, setting up her binder and her stamp pad. Richard sat next to her, scrolling his phone. The other board members trickled in over the next 20 minutes. There were a dozen residents in the audience. I recognized a few from the group chat. Glenn was there. Angela was there. Nobody talked to me, but a couple people nodded. Richard called the meeting to order and went through the agenda. There was nothing about my violations. There was nothing about the records demand. It was all routine business: budget updates, landscaping contract renewals, and a vote on holiday decoration guidelines. I raised my hand during the open comment period. Richard called on me. I said I had submitted a formal records demand 3 weeks ago, and I was still waiting for a response. I said New York law required the association to produce records within a reasonable time, and 3 weeks was not reasonable. Catherine cut in and said the matter was under legal review and would be addressed in accordance with attorney guidance. I said the attorney's letter was a stall tactic. She said the board did not take direction from residents. I said the law did not give the board a choice. Richard said my comment time was up. I said I was not done. He said I was. I said I would keep coming back to every meeting until I got access. He said that was my right, but disruption would not be tolerated. I sat down. Catherine smirked. After the meeting, Glenn caught up with me in the parking lot. He said he had been tracking the group chat threads, and 3 more people had come forward with backdated notices and fake fees. He said nobody wanted to file complaints because they were afraid of retaliation, but they were willing to talk if I was building a case. I asked him if he would testify. He said he would, but only if it did not cost him anything. I said I could not promise that. He said he would think about it. Angela walked up and said she had something I needed to see. She pulled out her phone and opened a photo. It was a violation notice, just like the one she had posted about. But this one was different. It was dated 2 weeks earlier than the one she had received. She said she had found it in her spam folder, buried under junk mail. She said the date on the email did not match the date on the PDF attachment. I asked her if she still had the original email. She said she did. I told her to forward it to me and not delete anything. She said she would. That was my first break. The metadata on Angela's email could prove Catherine was backdating documents, and if I could prove that, I could prove she was falsifying records. I went home and called Paul. I told him about Angela's email and asked if we could use it. He said yes, but we needed a forensic analysis to confirm the metadata was authentic. He said he could hire an expert, but it would cost another $2,000. I said I did not have $2,000. He said then, we had to use what we had and hope it was enough. I asked him what the timeline looked like. He said we could file a motion to compel next week, get a hearing in 3 to 4 weeks, and get a ruling a week after that. That put me 2 weeks past my refinance deadline. I told him I needed something faster. He said there was one option. He said if I could get a police incident number for fraud or harassment, that would force the HOA to freeze their enforcement actions pending investigation. He said it would not be a permanent fix, but it would buy me time. I asked him how I would get an incident number. He said I needed to file a police report and provide evidence of a crime. I asked if backdating notices counted. He said it did, but the police might not take it seriously unless I could show financial harm. I had financial harm. Catherine's fake fees were blocking my refinance, and if the refinance fell through, I would lose the lower rate and pay thousands more in interest. I just needed to connect the dots. I called the non-emergency line and asked to speak to an officer about filing a fraud complaint. The dispatcher said I could come to the station or request a callback. I said I would come in. The officer who took my report was a younger guy named Stevens. He listened to my summary and looked through the documents I brought. He said HOA disputes were usually civil matters, but if I was alleging document fraud, that could be criminal. He said I needed to show intent, which meant proving Catherine knew the rules she was citing were not real. I showed him the side-by-side covenant comparison. He said that was good, but it did not prove intent. I showed him Angela's backdated email. He said that was better, but he needed more context. I showed him the screenshots from the neighborhood group chat showing the pattern of backdated notices and fake fees. Stevens said he would take the report and forward it to the fraud division, but he could not promise anything. He said HOA cases were low priority, and it could take weeks before anyone followed up. He said if I wanted faster action, I needed to catch Catherine in the act. I asked him what that meant. He said if she tried to enforce a fake rule again, I should call the police on scene and show them the proof in real time. He said that would create a contemporaneous incident report, and that carried more weight than a delayed complaint. I said I would do that. He said good luck. Then he gave me the incident number and said to reference it if I called again. I left the station and drove to the management company's office. I had one more card to play. The records custodian, a middle-aged woman named Sharon, was the person Catherine sent all her enforcement requests through. If I could get Sharon to admit the fees were not in the covenants, that would be neutral third-party proof. Sharon was not happy to see me. She said Catherine had warned her I might show up, and that I was not authorized to access records without board approval. I said I did not need board approval. I needed the truth. I said Catherine was charging fees that did not exist, and I wanted to know if Sharon knew that. Sharon said she did not discuss internal matters with residents. I said this was not internal, it was public record. She said the HOA's financials were not public. I said the covenants were. She said I would have to talk to Catherine. I put the city clerk certification letter on her desk and said Catherine was lying. I said the covenants she was enforcing did not match the official filing, and if Sharon kept processing fake fees, she was complicit. Sharon looked at the letter. She did not say anything for a long time. Then she said she was not allowed to comment on board policies. I asked her if she had ever seen the real covenants. She said she worked off the versions Catherine provided. I asked her if she had ever compared them to the official filing. She said no. I asked her if she would. She said she could not. I asked why. She said it was not her job. I asked whose job it was. She said the board's. I left the office knowing Sharon was stuck. She was not going to help me, but she was not going to help Catherine either. She was just going to keep her head down and process whatever Catherine told her to process. That meant I had to force Catherine's hand myself. I went back to the neighborhood group chat and posted a thread. I said I was collecting evidence of backdated notices and fake fees, and I needed anyone who had been hit with unexplained charges to reach out. I said I had proof the HOA was enforcing rules that did not exist, and I was building a case. 3 people replied within an hour. One said they had been fined for a mailbox color violation, even though their mailbox was the same color as everyone else's. One said they had been charged a $50 appeal fee to dispute a parking notice, and when they paid it, the notice was dropped without explanation. One said Catherine had threatened them with a lien for unpaid landscaping fees, but when they asked for an invoice, Catherine said the fees were rolled into dues and did not require separate billing. I asked all 3 for copies of their notices. They sent them. Every single one referenced rules that were not in the official covenants. Every single one was signed by Catherine. I had 5 residents now, all with the same pattern. Backdated notices, fake fees, threats of liens and towing, and Catherine as the common thread. I called Paul and told him what I had. He said it was enough to file a class action if we could get more plaintiffs, but that would take months. I said I did not have months. He said then we needed to go nuclear. I asked him what that meant. He said we needed to demand an emergency board meeting, present the evidence in front of the entire membership, and force the board to either fire Catherine or explain why they were protecting a fraud. I said Catherine would never allow that meeting. He said she did not have a choice. He said New York law allowed members to petition for a special meeting if they collected signatures from 20% of the membership. He said Canyon Springs Commons had 200 units, so I needed 40 signatures. I asked him how long that would take. He said if I worked fast, maybe a week. I started knocking on doors that night. I brought printed copies of the side-by-side covenant comparison and the backdated notice screenshots. I kept my pitch simple. Catherine is charging fees that do not exist. I have proof, and I need your signature to force a meeting where the board has to answer for it. Some people signed immediately. Some people said they did not want to get involved. Some people said they had been hit with fake fees too, but they were afraid of retaliation. I told them this was their chance to fight back. I told them if we did nothing, Catherine would keep doing it. By the end of the week, I had 63 signatures. More than enough. Paul drafted the petition and filed it with the board. The law required the board to schedule the meeting within 30 days. Catherine tried to delay it by claiming the petition was defective because some signatures were not notarized. Paul replied that New York law did not require notarization for membership petitions. Catherine did not respond. Richard sent an email 2 days later, confirming the meeting was scheduled for the following Thursday at 7 p.m. He said the agenda would be limited to the petition topic, which was records access and fee transparency. Catherine sent a separate email saying the meeting would be recorded by the association and personal recordings were prohibited. I forwarded it to Paul and asked if she could do that. He said no, and he would be attending the meeting with a camera. The meeting room was packed. Every chair was full, and people were standing along the walls. Glenn was there. Angela was there. The 3 people from the group chat were there. Paul was there with his camera. Catherine sat at the head table with her binder and her stamp pad, looking calm. Richard called the meeting to order and said the petition had requested a discussion of records access and fee transparency. He said the board would hear from the petitioners, then respond, then open the floor for member comments. Paul stood up and introduced himself as my attorney. He said the petition was filed because the board was enforcing rules that did not exist in the recorded covenants, and the board secretary had been charging fees that had no legal basis. He said we had evidence of backdated notices, fake compliance violations, and a pattern of harassment targeting residents who asked questions. Catherine stood up and said the accusations were defamatory. She said the board had full authority to adopt operating rules, and all fees charged were within the board's discretion under the covenant's general management clause. Paul asked her to cite the clause. She flipped through her binder and said it was Article 3, Section 2, General Powers of the Board. Paul pulled out the city clerk's certification letter and read the section aloud. It said the board had authority to manage common areas and enforce the recorded covenants. It did not mention adopting new rules. It did not mention fee discretion. Catherine said the clause had been interpreted by the board's attorney to include operational authority. Paul asked to see the attorney's opinion. She said it was privileged. Paul said if the opinion was privileged, it could not be used to justify enforcement actions against members. He said the board could not hide behind attorney-client privilege to enforce rules that did not exist. Richard cut in and said the board stood by its authority. He said if members disagreed, they could file a lawsuit, but the board was not going to litigate policy in a membership meeting. I stood up and said we were not litigating policy, we were exposing fraud. I said Catherine had been backdating notices, inventing fees, and using the tow vendor to harass residents who questioned her. I said I had 5 residents who were willing to testify, and I had proof. Catherine stood up and shouted that I was out of order. She said I did not have proof, I had screenshots and hearsay. She said if I continued to make accusations, she would file a defamation suit. I pulled out my phone and opened Angela's email. I held it up and said the metadata showed Catherine had backdated a violation notice by 2 weeks. I said that was fraud, and I had the forensic proof. Catherine said my camera did not matter. Her minutes were the truth. Paul stepped forward and said he had forensic confirmation from an independent expert, and he was prepared to submit it as evidence if the board refused to act. He said the expert's report showed at least 12 instances of backdated notices over the past 18 months, all signed by Catherine. The room went silent. Richard looked at Catherine. Catherine did not look at anyone. She just sat down and opened her binder. Richard said the board would take the matter under advisement and issue a response within 10 business days. Paul said that was not acceptable. He said the board needed to suspend all pending enforcement actions immediately and conduct an independent audit of all fees collected in the past 2 years. Richard said the board would not be dictated to by residents. Paul said the board did not have a choice. He said if the board refused, we would file a motion for a temporary restraining order and an injunction, and we would name every board member individually. Richard looked at the other board members. Nobody said anything. Then he said the board would take a 15-minute recess to confer. Catherine did not move. She just sat there, staring at her binder. During the recess, Glenn came up to me and said he had something I needed to hear. He said another resident, a woman named Carla, had been going through old HOA meeting minutes and found something strange. She said the minutes from the meeting where the grounds maintenance fee was supposedly approved did not match the video recording of the meeting. She said the minutes showed a unanimous vote, but the recording showed 2 board members objecting and Catherine overruling them. I asked Glenn where the recording was. He said Carla had it on a thumb drive. I asked if she was here. He pointed to a woman sitting near the back. I walked over and asked if I could see the recording. She handed me the thumb drive and said she had made copies because she did not trust Catherine not to delete the original. I gave the thumb drive to Paul. He plugged it into his laptop and pulled up the video. It was 40 minutes long. He scrubbed to the timestamp where the grounds maintenance fee was discussed. The board president at the time, a different guy named Warren, asked for a motion to approve the fee. One board member, a woman named Linda, moved to approve. Another board member, a man named Joe, said he wanted to see a cost breakdown first. Catherine said the breakdown was in the budget packet. Joe said he did not see it. Catherine said it was on page 16. Joe flipped through the packet and said there was no page 16. Warren said they could table the vote until the next meeting. Catherine said that was not necessary because the fee was already included in the adopted budget. Warren said he did not think that was accurate. Catherine said it was, and she would provide documentation after the meeting. Warren said he wanted the documentation before the vote. Catherine said the documentation was confidential financial analysis and was not subject to member review. Linda said she moved to approve the fee as presented. Warren asked for a second. Nobody seconded. Warren said the motion failed for lack of a second. Catherine said the motion was approved by default under the board's consent agenda process. Warren said there was no consent agenda. Catherine said it was in the bylaws. Warren asked to see the bylaw. Catherine said she would provide it after the meeting. The video ended. Paul looked at me and said Catherine had fabricated the vote. Richard called the meeting back to order. He said the board had conferred and decided to suspend all pending enforcement actions for 30 days, while an independent management consultant reviewed the association's procedures. He said Catherine would remain in her role as secretary, but all enforcement decisions would require board president approval during the review period. Paul stood up and said that was not good enough. He said Catherine needed to be removed immediately, and the board needed to retain a forensic accountant to audit all fees collected under her authority. Richard said the board did not have the authority to remove an elected officer without a membership vote. Paul said the board had the authority to suspend an officer for cause, and fraud was cause. Richard said there was no finding of fraud. Paul said we had the evidence right here, and if the board refused to act, we would go to court tomorrow. Richard looked at Catherine. Catherine did not say anything. Then Richard said the board would vote on a temporary suspension, pending the completion of the consultant's review. The vote was 3-2. Catherine was suspended. She stood up, slammed her stamp pad on the table one last time, and walked out. The room erupted. People were clapping, shouting questions, demanding answers. Richard tried to regain control, but nobody was listening. Paul leaned over and said we had won the first round, but the fight was not over. He said Catherine would lawyer up, and the board would try to minimize the damage. I said I did not care about minimizing damage. I said I wanted every fake fee refunded and every backdated notice expunged. Paul said we would get there, but it would take time. I asked him how much time. He said months, maybe a year. I said I did not have a year. My refinance was due in 2 weeks. Paul said he would file an emergency motion to compel the association to provide a clean title letter confirming no liens were pending. He said if we could get that, the lender would close. He said it was a long shot, but it was the only shot we had. I told him to do it. The motion was filed Monday morning. Catherine's attorney opposed it, arguing that the suspension was procedurally defective and that Catherine retained her authority as secretary. The judge scheduled a hearing for Thursday. Thursday came. Paul and I showed up with the thumb drive, the backdated notices, the side-by-side covenant comparison, and the forensic metadata report. Catherine showed up with her attorney and her binder. The judge listened to both sides for 20 minutes. Then he asked Catherine's attorney to explain why the association was enforcing rules that were not in the recorded covenants. The attorney said the rules were board-approved interpretive guidance. The judge asked to see the board resolution approving them. The attorney said the resolutions were in executive session minutes. The judge said executive session minutes were not a substitute for recorded amendments. The judge turned to Catherine and asked her directly if she had backdated any violation notices. Catherine said no. The judge asked if she was aware that forensic analysis of email metadata showed at least 12 backdated notices. Catherine said the analysis was flawed. The judge asked if she had any evidence to support that. She said no. The judge issued an order from the bench. He said the association was prohibited from enforcing any rule not contained in the recorded covenants. He said all fees collected under unrecorded rules had to be refunded within 30 days. He said Catherine was permanently enjoined from issuing violation notices or collecting fees on behalf of the association, and he said the association had to provide me with a clean title letter within 48 hours. Paul smiled. Catherine did not. We walked out of the courthouse, and I called my lender. I told them the title letter was coming and the refinance could proceed. The loan officer said they would need to see the letter before they could clear me to close. I said it would be there by Monday. It was there by Friday. I closed on the refinance the following Wednesday. The rate locked in, the lien threat was gone, and Catherine was out. But the story did not end there. 2 weeks later, the management company terminated their contract with the tow vendor. Turns out the vendor had been paying Catherine a referral fee for every car they tagged, which explained why she was so aggressive about pushing re-inspections. The board launched a full audit and found that Catherine had been collecting unauthorized fees for 3 years. The total was over $40,000, all of it unreported on the association's tax filings. The board fired the management company, hired a new one, and the new management company immediately flagged Catherine's fee scheme to the state attorney general. Catherine was charged with fraud and embezzlement. She pleaded no contest and was sentenced to probation and ordered to pay full restitution. The funny part? The favorite fee Catherine had been charging, the one she used most often to shut people up, was the administrative review fee. The forensic audit proved it was completely imaginary. There was no line item for it in the ledger, no board resolution authorizing it, and no record of where the money went. Catherine had just been pocketing it. Glenn got his money back. Angela got hers. Carla got hers. Every resident who had paid a fake fee got a refund check within 60 days. The board agreed to mediation with a neutral third party to revise the association's governance policies, and they adopted a new rule requiring all enforcement actions to cite specific recorded covenant sections. Catherine lost her committee role immediately, and she resigned from the board entirely a month later. Last I heard, she moved out of Canyon Springs Commons. The neighborhood is quieter now. The new management company does not play games. The board does not rubber stamp everything Catherine says. And residents actually get answers when they ask questions. As for me, I got my refinance, my clean title, and my sanity back. And I learned that when someone tries to bully you with fake paperwork and invented rules, the best revenge is just showing them the real ones. I hope your neighborhood stays drama-free.